Hello, I'm Robin Henry, Head of Insolvency Litigation at Collier Bristow. I want to give you a brief overview of a new authoritative statement of how English law views crypto assets in insolvencies. With crypto or digital assets becoming more widespread, this is something that all insolvency practitioners should be aware of. Technically, what we're talking about is the UK jurisdiction Taskforce's legal statement on digital assets and English insolvency law, published on the 17th of April 2024. What it seeks to do is to apply the principles of English insolvency law to digital assets. It's not legally binding, but since it's been produced by senior judges, the Law Commission and other legal professionals, it's likely to be relied on by the courts as an accurate reflection of the law. Here are some of the most important points you should be aware of. First, digital assets are property for the purposes of English insolvency law. The definition of property in section 436 of the Insolvency Act is extremely wide, wider than common law, so there can be no doubt that it includes digital assets. But as with other property, a digital asset may be outside the scope of particular insolvency procedures. For example, if it's held as trust property. And that might be the case where a crypto exchange holds the digital assets on behalf of multiple clients. This is important in the context of restructurings, since the proprietary rights of a beneficiary under a trust can't be compromised in schemes of arrangement, CVAs, and restructuring plans. Digital assets are not recognised as money or foreign currency. However, this might change in the future if cryptocurrencies become commonly accepted as a means of exchange or a unit of account. But if digital assets are not yet money, then they can't be a liquidated sum and form the basis of a statutory demand, and the FCA rules relating to client money are also unlikely to apply. Nevertheless, digital assets may come within the definition of a provable debt for the purposes of making a claim in an insolvency. So a creditor could make a claim in respect of an obligation to deliver crypto assets. Now, the virtual nature of digital assets means that they're likely to be connected with multiple jurisdictions. While in non-insolvency cases, the courts have already held that a crypto asset is located at the place of domicile of its owner. For the purpose of establishing the correct jurisdiction for opening insolvency proceedings, the statement says that the courts should continue to apply existing COMI principles for companies which have digital asset businesses. The question of how English law should approach the conflict of law issues which may arise where digital assets are actually physically located or are located in other states was outside the scope of the statement, and that remains an open issue. Finally, antecedent transactions. There shouldn't be a problem in challenging antecedent transactions involving digital assets. However, there is one issue that because a transfer of digital assets on the blockchain can't be physically undone, the courts would not be able to order the assets to be retransferred. Nevertheless, the courts do have the power to make other orders to bring about effectively the same result, such as an order requiring the recipient to make an opposite transfer on the blockchain. Those are the main points that I wanted to get across, but if you want any more information on this issue, please do feel free to contact me or another member of our insolvency team at Collier Bristow.